A very pleasant good afternoon to the residents of District 7, in particular, the rest of Anguilla, and indeed those of you joining us via Radio Anguilla 95.5 FM in Anguilla, Lloyd's Live, or Government of Anguilla Live. We are here at the Auditorium of the Alwyn Allison Primary School, and we have lots of room. In here this evening, we can safely accommodate 18 or so persons. We are all properly social distanced, and we invite members of the community in particular to come out and join in our discussion this evening. Before we begin, we just start with a word of prayer. Dear Lord, we thank you for this opportunity to be here this evening to again discuss the affairs of this country, in particular the upcoming constitutional reform. We ask for your blessings upon the people of Anguilla. We ask for your protection on our health workers, our police officers, all those who are charged with the protection of our borders and the health and well-being of our people. We ask your guidance upon the session here this evening, that you may guide our thoughts and our words and our actions to impart the maximum benefit to the listeners and viewers here this evening. We ask these blessings in your name. Amen. Good evening. I would like to acknowledge the presence of the Honorable Premier, Dr. Ellis Webster, retired High Court Judge Justice Don Mitchell, members of the audience, our listeners via Radio Anguilla, and our viewers on gov.ai in Anguilla and Lloyd's Live. I begin as I began last Thursday with the opening stanza of our national song. God bless Anguilla, nurture and keep her, noble and beauteous, she stands amidst the sea. O land of the happy, a haven we'll make thee, our lives and love we give unto thee. Ladies and gentlemen, welcome to this, the second in the series of town hall meetings that the Ministry of Home Affairs is organizing to solicit the views of the general public on constitutional reform. I would like again to state that in the APM 2020 elections campaign manifesto policy, by way of a vision statement, we stated inter alia that the Anguilla Progressive Movement, APM, understands that enhancing the foundation of a great society means investing more in its people and empowering them to take ownership of their own destiny. Charting our own destiny means that we have the right to self-determination as the United Nations Charter mandates, and consequently, as a people, we have to reach a consensus on a roadmap on how this can be achieved. Last week, we began this series of town hall meetings on constitutional reform in Island Harbor by taking a look at how Anguilla's constitutional status has evolved and the proposals currently under discussion and consideration with the United Kingdom government. Working on the assumption that many of you are joining us for the first time tonight in this presentation, the presentation will cover much of the same material as last week, but will also delve into some additional areas. Again, as mentioned last week, constitutional talks were undertaken with the United Kingdom government in November 2019 under the tenure of the AUF administration by a cross-party team and representation from organizations such as the Anguilla Bar Association. We have posted online the draft constitution arising from those discussions, and you can find that at gov.ai. To briefly state, the new draft constitution covers the following: Preamble, Part 1, Protection of Fundamental Rights and Freedoms, Part 2, Interpretation, Part 3, the Governor, Part 4, the Executive, Part 5, the Public Service, Part 6, the Legislature, Part 7, the power and procedures in the House of Assembly, Part A, the Judicature, Part 9, Institutions Protecting Good Governance, Part 10, Public Finance, and Part 11, Transitional and Miscellaneous. Ladies and gentlemen, constitutions do not make light reading. However, we are duty-bound to ensure that the members of the general public understand as much as possible what is being proposed and to seek your sanction. As Nelson Mandela would have observed, an educated, enlightened, and informed population is one of the surest ways of protecting the health of democracy. I do sincerely hope that the general public will find these series of town hall meetings informative and enlightening. We are somewhat hampered by the health restrictions occasioned by the ongoing COVID pandemic in terms of the numbers of persons being able to physically attend these sessions. That is why we are so happy to have partnered with in Anguilla, DITES, and Radio Anguilla to bring these sessions to you. I also want to acknowledge the invaluable assistance in this regard being provided by my able and capable Permanent Secretary, Dr. Aidan Harrigan, and other technical staff at the ministry. Before I get to Dr. Harrigan, I just want to acknowledge the presence of Reverend Wilmoth Hodge. He is the president of the Anguilla Christian Council, and our parliamentary secretary, the Honorable Quincy Gomes Mary. With all the above having been said, I now invite Permanent Secretary, Home Affairs, Dr. Aidan Harrigan, to present on Anguilla's constitutional evolution and the key changes under consideration for this round of constitutional reform. Following that, the floor and our online platform will be open to accept your questions and comments. Thank you, Dr. Harrigan.
Thank you, Minister Hodge, and good evening to everyone, those here in the auditorium and also listening via the various media. I would like to adopt the protocol established. Right. So, as Minister Hodge would have referred to, the United Nations, through the Charter, has what they call an international legal mandate, and this states, all peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely determine their economic, social, and cultural development. The United Nations in 1946, by way of United Nations Resolution 66-1, established a list of non-self-governing territories. Then in 1960, via UN Resolution 1541-15, the UN identified that self-determination is attained through three modes: independence, free association, and integration. The UN in 1961 established a special committee on decolonization, the Committee of 24. The United Kingdom government, as Anguilla's administering entity, is obligated to report on an annual basis on progress with the non-self-governing territories attaining self-determination. The United Nations has declared a number of what they call international decades on decolonization, starting with the first one in 1991, which went to 2000, with the intention that all the non-self-governing territories would have been removed, would qualify for removal from the list by the end of that period. But however, there are still a number of non-self-governing territories, Anguilla included. There are 17 remaining. So modes of self-determination, independence, and that is, fairly known in that we have in the Caribbean, most of the Caribbean countries are independent, and such as Jamaica, where with independence, a country has its own government and is not ruled by any other state or country. Free association, and the definition commonly used, free association shall be the result of a free and voluntary choice by the peoples of a territory concerned, expressed through informed and democratic processes, and should permit the right to determine the internal constitution without outside interference. An example of that is Puerto Rico and its association with the United States of America. Then we have integration, and by definition, this should be on the basis of complete equality between the people of the former territory and the country into which it is being integrated. So examples are, in our region, are Martinique and Guadeloupe, integrated with France. So running through Anguilla's evolution quickly through the centuries, Anguilla was established as a British colony in 1650 and administered through Antigua. Then in 1825, administration was switched to St. Kitts. In 1967, the UK established the Associated State of St. Kitts Nevis Anguilla, and that status represented a semi-independent status of the tri-state. So, as you may know, from 1958, the UK had attempted to decolonize its Caribbean territories through the West Indies Federation, and that did not work. You remember a famous quote, I think, from Eric Williams in Trinidad. There were 10 territories. Well, some were linked together. And when Jamaica decided to go on its own, he said, one from 10 leaves 0. So it's a play on words. Here in Anguilla, there was a referendum held in July. Before that, we had the events leading up. We had in May 30th, in 1967, when the Kittitian police were expelled, and that is a day which we celebrate to this day, Anguilla Day. And later on in that year, there was a referendum, and Anguillians voted overwhelmingly to secede from the tri-state. A constitution was adopted, one formulated by Harvard professor Roger Fisher. There was a second referendum held on February 6, 1969, in which Anguilla, there was a unilateral declaration of independence. And the constitution used was one formulated by another American citizen, Jack Holcomb. In response to that, in March 1969, British troops invaded Anguilla, and direct rule from Britain was established eventually through the Anguilla Act of 1971, and that arrangement has obtained in various forms ever since. In 1976, there was a new constitution. There was a constitution adopted, and that provided for the ministerial system of government, which again obtains to this day as we'll see some changes. In 1980, the other event of note, there was and the Anguilla Act passed, which empowered Her Majesty to separate Anguilla from the associated state of St. Kitts, Nevis, and Anguilla. And the date appointed was December 1980. And I would have indicated at the town hall meeting last week, it really depended on a administration in St. Kitts, which was sympathetic to what Anguilla wanted to achieve. And the administration in power at that time in St. Kitts, Nevis was the PAM administration led by Dr. Kennedy Simmons. In 1982, there was another constitutional order, and which was subsequently amended in 1990 to provide for things like a leader of the opposition. And then there was no further amendment until 2019, where there were 3 changes made, which we will get into later. So in terms of attempts at constitutional reform, in 1999, there was a major shift in terms of the UK government approach, and this was associated with the Labour government. They published a paper which was called, a policy paper which was called Partnership for Progress and Prosperity. And one of the outcomes of that paper was to rename at the time they were called dependent territories, and to rename the UK dependent territories as overseas territories. The policy paper also encouraged the establishment of constitutional review commissions in the various territories, and that the territories should make submissions to the UK government for constitutional change. But amongst that, the UK government was quite clear to indicate that overseas territories who wished to go independent, they could do so once it was the clearly expressed wish of the majority of the people, determined by a referendum or some other accepted means. However, it ruled out integration with the UK or free association. Remember earlier I had indicated that the UN provides for three ways in which countries can be said to have progressed to a form of self-determination. So in terms of the constitutional reform efforts, in 2001, there was a committee established and held a lot of consultations and meetings and so on, but for one reason or the other, no formal recommendations were made. Another event of note was that in 2003, the United Nations actually held a decolonization seminar in Anguilla, and it was the first time that it was held in a non-self-governing territory. And in the UK was also represented. So you had representation from members of the Committee of 24, the countries, and also the UK government as the administrative power. And Anguilla represented, of course. This was under the administration led by Mr. Osmond Fleming. So after the attempt in 2001, we had to wait until 2006 before another attempt was made. And again, a number of consultations, meetings, and so on. And a report was tabled within 6 months. But no definitive decisions were taken. And we had to wait until 2015 when another attempt was made. And this time it occurred over a period of 2 years, and a formal report and draft constitution was submitted. Okay, so what you can say, ask what was the driving force behind the effort in between 2015 and 2017. You could argue that the Anguilla Constitution in its origin is a constitutional dictatorship, in that the Anguilla Act of 1981 provides tremendous powers to the UK government. For example, the UK government could impose direct rule unilaterally through an order of council. So the mindset and the view from the general public in terms of the consultations was that there needed to be an improvement in democracy in Anguilla, our framework and processes, but also that there needed to be an improvement in the standards in public life. So as I said, this would have driven or guided the recommendations that the Constitutional Committee of 2015 to 2017 would have made. So looking at Chapter 6, so I must apologize here. In subsequent presentation, I will adopt the chapters in the draft constitution, as Minister Hodge indicated. Following the discussions in November 2019, the UK government would have submitted a draft covering all that was discussed in areas that remain outstanding. In any event, there, as I said, and as Minister Hodge indicated at the beginning, there are a number of chapters in the draft constitution, and not taking it strictly from Chapter 1, I jumped to Chapter 6. One of the areas that was highlighted and is given a lot of importance is the need to regulate campaign finance. And with the view that, and this is something that is very common in developed countries, the UK, the US, countries like New Zealand, Australia, for example, and that there should be equal or level playing field, or it shouldn't be a distortion in terms of the ability, whoever wants to put themselves forward for public office. And so the only way you can really know what is happening is to have campaign finance legislation and a policy and so on behind that to set limits and as to how persons or entities can contribute to financing the campaign of a particular party or individuals. If we say that self-determination is a pathway, there's a strong view that if we are to aim for independence, there must be institutions that will protect good governance. And currently, this is an area that is lacking. So what has been recommended is that there be various commissions and our commissioners. And examples are, well, we have some already, but so like there's already a public service commission, there's a police service commission. Recommended, there's an Electoral Boundaries Commission, there's already Anguilla Status Commission. There is provision in the Procurement Act for Public Procurement and Contract Service Commission, but that has not been activated. There's already a Financial Services Commission. It's also recommended that there be an Appointments Commission. In recent times, we've heard quite a lot on the various talk shows about membership on the boards of statutory bodies and so on. And what is recommended is that such appointments of such directors would be done by an appointments commission. And so there would be a criteria against which directors would be selected and then appointments made. There is a Judicial and Legal Services Commission already. What is also being proposed is an Integrity Commission and the provision to have commissions of inquiry. And with commissions of inquiry, you may know that currently there's one on the way in the BVI. And commissions of inquiry can have broad scope, and nobody is immune from the very top, from the premier or if it's an independent country prime minister right on down through the various levels of administration. There's also proposal to have a human rights commissioner, complaints commissioner, and freedom of information commissioner. Freedom of information, again, if you follow, this is something that is not current in the Anguilla system, but if you follow events in, say, the United States or the UK, you find that folks can write to the government, and the government is obligated to provide the information requested. And so the view is that if you are to hold your government accountable, you must be able to have access to information. Right. Improving standards in public life continued. There's also in the draft constitution provision for Chapter 10 as regards to public finance. If you look at the existing constitution, which, as I said, goes back really to 1982, there's very little by way of reference to public finance apart from a reference to appointment of a chief auditor and so on. Most of what is proposed in that chapter is taken from a draft Anguilla 2015 order. In 2015, the UK government was considering passing by way of an order in council such a order which deals with public finance, but for whatever reason it was not enacted. And when you look at, because we've been looking at the various constitutions of our fellow Caribbean overseas territories, we would have noted that most of the provisions in the draft order actually show up in the TCI 2011 Constitution. And the Turks and Caicos Constitution is actually the most recent of the overseas territories. And so, I mean, throwing out a question there, in terms of public financial management, are the provisions in the TCI Constitution, 2011 Constitution, therefore the new gold standard, as it were, that the UK is insisting on when it comes to public financial management. If you, again, some context, as you remember in the late 2000s, 2008, I think, maybe 7, 8, the UK government would have suspended the TCI Constitution and undertook direct rule. And one of the things that the UK government places a lot of stock is that it's something which they call contingent liabilities. And again, if you listen to the various press conferences from government, various governments over the years, you hear that term referred to. Basically, it in a nutshell, if one of the applications is if an overseas territory were to go bankrupt, for example, the UK government is obligated to assist the territory to meet its obligations. And the UK government has taken the approach that they would want to be preemptive and not allow a territory to, to reach that stage. And so I think that what you see showing up in the Constitution in terms of public financial management and the TCI and so on relates to that. Behind, in terms of provisions of the what is proposed, again, something you would have heard quite a bit about if you attend government public presentations on finance and so on, is something called the Fiscal Responsibility Act. And it covers a lot of areas, and one of the areas that is discussed quite a bit is what is called the borrowing ratios. And it sets limits in terms of how much the maximum debt that a country can undertake. It makes provisions, it sets limits in terms of debt service, prudential ratio, and it also provides for a rainy day fund in the sense that it stipulates that countries ought to have set aside enough reserves to cover 90 days worth of recurrent expenditure. And all of the overseas territories, the Caribbean overseas territories, have some version of the Fiscal Responsibility Act. What is proposed is that in Anguilla's case, that there be the formulation of a new framework, and then once that is done, then that becomes part of the framework for Anguilla, and the existing Fiscal Responsibility Act would have to be repealed. So there would have to be negotiations between the UK government and the government of Anguilla in terms of what form that would take. Something that in going through we picked up on, and I have to say here is that one part of the process of constitutional reform, when you get through when you agree the major issues and principles, is to have a drafting team to go through and present the draft for consideration. And drafting is it's a particular skill, right? Not everybody can do that. And I said that to say that, and what the UK government is proposing is that there be a clause in the Constitution that sets out the authorities or powers of the UK government through the governor as relates to the public finance provisions. This does not appear in the TCI Constitution as far as I'm aware. I may be wrong. You may ask, and noting the comment that the UK government made in its note, it seems to say, well, having an explicit, and maybe Mr. Mitchell can provide some light, having an explicit reference to the powers does no harm, does no violence, because if you look at other sections of the Constitution, the governor has various authorities, and so this is just basically restating it in a very obvious way. But it's something that the government will have to take a position on. Powers of the UK governor. The UK governor, most of the powers remain as such as they were going back to the 1982 Constitution. As I would have mentioned earlier, the UK government takes the viewpoint that once, if a territory decides to maintain its link with the UK government as an overseas territory, then that has implications for the UK government. The UK government is a signatory to a number of international obligations, and so therefore it has to ensure that, and also where the territories are signatories to such obligations, that they live up to such commitments. And as I mentioned earlier, management of UK contingent liabilities so that they do not get out of hand. The executive the executive authority of government of Anguilla is vested in Her Majesty. The proposal is that currently there's an executive council, and the proposal is that it be renamed as cabinet, and that the cabinet shall consist of a premier, which has been renamed from chief minister in earlier constitution. Not more than 5 other ministers, and then 2 ex officio members in terms of the Attorney General and the Deputy Governor, and that cabinet be chaired by the Governor as the UK representative, as Her Majesty's representative in Anguilla. Chapter 1, Protection of Fundamental Rights and Freedoms. Again, as I mentioned earlier, since Anguilla remains an overseas territory, the UK government is insisting on provisions that allow the UK government to properly execute its obligations, commitments to such, to international conventions and so on. One example of this, and when the UK team was in Anguilla in 2019, November 2019, for the constitutional talks, there was, if you remember, there was a town hall meeting, and I think it was one of the dominant issues being discussed was surrounding marriage and what constitutes marriage. The government of Anguilla has proposed language stating that viewing marriage as being between persons of the opposite sex, while the UK insists on no such limitation, as to do so would put Anguilla at odds with the European Convention on Human Rights, for example. Anguilla is a signatory to that convention, which does not allow for discrimination on the basis of sexual orientation. So this is the precise language has not agreed. It's not been agreed. It's one of those outstanding items from the talks in November 2019. But I think for those who were listening there, I think you got the impression that, as I said, the UK would be quite firm in insisting on language that allows them to discharge their duties under those conventions. Sorry, I was checking something. My apologies. I think in doing an edit, I would have missed one slide that would have generated a lot of discussion in the previous town hall meeting. So if you give me a couple minutes.
So while we are waiting on the Permanent Secretary to make that edit, just want to continue to invite the residents of District 7 in particular to come out. We have lots of chairs here, empty. So please come on out and join in this town hall meeting. And just remind persons as well that the draft that the Permanent Secretary has been referring to is available on the Government of Anguilla website. You can download it, or you can drop me an email at kenneth.hodge@gov.ai, and I'll be happy to forward you a copy of the draft Constitution. It is important, and I want to reiterate again, that we are being very deliberate in moving to the 7 districts. We want the persons in the 7 districts to be part of this process. Everybody is invited, but in particular, we are taking time to go to all of the districts to ensure that we give each district an opportunity to participate in this process. Unfortunately, you ready, sir?
Yeah.
Okay, I'll shut up for now. Go back to the PS.
Right, so this, the section that ought to have been there relates to the number of elected representatives. So, as you know, the last elections arising out of the amendment which was made to the Constitution in, I think it was May of 2019, provided for what is called island-wide voting. And so 4 candidates, 4 representatives of the House of Assembly are now elected on that basis. However, the draft Constitution actually provides to go even further in terms of increasing the numbers in the House of Assembly, elected members of the House of Assembly, so that it should not have less than 13. And as you know, also one of the consequences of the changes adopted in May 2019 was that we no longer have nominated members. So the proposal in the draft constitution is that you have, as I said, 4 members elected on an island-wide basis, and no less than 9 representatives elected on a district basis. Currently, there are 7 elected members elected on a district basis. Importantly, the Constitutional Committee would have recommended that any changes in terms of the district representation should be done by a district boundaries commission, and also have the basis in law. Minister Hodge at a recent press conference would have indicated that there are different ways of going about adjusting the representation. Right now, in the 7 districts, we have relatively small districts such as the district that we are in here tonight, West End, and also Sand Hill, district number 2. And then we have, large districts such as Valley North and Valley South, and then also Road North and Road South. And so one alternative would be, also incorporating population data would be to have a more even spread of the population in the districts, adjust the districts on that basis. Or alternatively, you could increase, as I said, the number from 7 to 9. So again, this is something that the government, subject to the views that are made known by you, the public, would have to consider. And one other alternative that has been proposed in terms of representation is to have elections, all representatives elected on the basis of the island-wide elections. Another proposal in the draft constitution is to in terms of the ex officio members, the Attorney General and the Deputy Governor, to restrict them so that they would not be able to vote in the House of Assembly. And this is a very topical issue in recent times, given what transpired with the passage of the GSA bill in July of this year. So why the push for having more representation in the House of Assembly? Basically is to avoid what is called the House of Assembly being a rubber stamp, in that in the House of Assembly you have members who comprise Executive Council, and they would be the ones who would have passed policy, would propose legislation to go to the House of Assembly and so on. And so that rather than having the will of Executive Council members just imposed on what is passed, that there will be provision in the House to have spirited debate, and at the end of the day, whatever the view that will attract a majority that would carry the day. So moving on, one of the issues that came up in the discussions, the talks in November 2019, was the question of should the Constitution have a clause that provides a framework for triggering the process of independence? And the UK government response was that in their view, the Anguilla Act of 1980, which gave rise to Anguilla's separation from the St. Kitts Nevis Anguilla, does provide for Anguilla becoming independent if it wanted to. So, is that sufficient, or should there be something in this constitution that references independence? I would have mentioned earlier one of the amendments that would have been adopted in the May 2019 constitutional amendment was to allow for island-wide voting. Another change was to change the name of the leader of government business from chief minister to premier. And another provision was to allow for the great-grandchildren of persons born in Anguilla to attain Anguilla status. So in concluding, 3 questions can be asked. Do the proposed changes satisfy the demand for increased democracy? Do the proposed changes satisfy the demand for improved standards in public life? And are there any other principles of note or provisions which you, the general public, would want reflected in the revised Constitution? Thank you.
Thank you very much, Dr. Harrigan. We now open the floor for questions. There was a question on the live that referred to the fact that in the previous discussions, the Premier was identified as the chair of cabinet, but in the draft we are looking at, it is still the governor. I don't know, Mr. Mitchell, you have been around this process for a while. You have any idea? And welcome, sir, again to this second meeting.
Thank you, Mr. Minister. First of all, let me specially congratulate you on taking the lead in this exercise of bringing back to the public the issue of constitutional reform. Somebody had to do it, and I'm glad that you're doing it, because this puts government authority behind the process. Mm-hmm. The way we had it before, it was more of a committee-led initiative, which didn't give it the same force and authority as your initiative now does. The second point I'd like to make before I get on to the question of the governor chairing cabinet meetings is, because I don't know if I'll get another opportunity, so I'm going to take advantage of my bully pulpit of having the microphone in front of me at this moment. The point that members of the public have made in the past is that there are 2 kinds of public meetings that are common in Anguilla for issues such as this, discussing reform or discussing new events as they occur. The most common form of public meeting is what is described as an information meeting. We all remember, for example, when the last administration was going to pass the new Labor Act, they held a number of meetings, and members of the public had very little opportunity to express their views. The meetings consisted mainly of officials giving information to the public on what was in the proposed law. So we had to sit down and listen to information without any real public involvement or any real discussion. And I would urge you, as these meetings progress, to consider in what way you can get the comments and the questions that are coming out on the various social media that you have in front of you, so that you can get those questions asked in great abundance and different people giving answers, so that people can feel that they are genuinely being involved in these public discussions, and try to limit the public information as much as possible to the least minimum amount. And then I must also congratulate you for putting the British, I'm going to call this the British draft constitution, this new constitution that went up, I assume either yesterday or today, very, very recently, is the British draft constitution. Now, the British negotiating team had promised Anguillians back in November of 2019 that by December they would send us their draft, which would include their proposals, which we hadn't yet agreed on, and the different issues that had been agreed in the November 2019 meeting. They would incorporate them in their draft so that we could see what the proposed new constitution, which would incorporate their proposals and our agreed with the British proposals for making changes. So we could study it, analyze it, discuss it, and feel that we were adopting something that we agreed with. Now, I have been writing in various forums my objection to the British having delayed for 2 years in sending us a draft constitution. Personally, I am a little disturbed to discover that the British did do exactly what they said, and they sent us the British draft constitution since about December 2019. We could have been discussing this draft under the previous administration, which refused or declined to inform anybody, certainly not me, who was then had been the chair of the committee, no hint or mention of the British draft having been received. This new administration has now been in power for more than a year, and it's only yesterday that we are learning that this British draft constitution is available and has been now for a couple of years. So I would urge that great effort be taken to ensure, as you have promised to do, that this draft is put into the hands of everybody who is interested in constitutional reform, and no effort should be made to keep it secret any longer. It's not a British document. It is eventually going to be our document. And we must feel that we really are considered important. By we, I mean the members of the Anguillan public. Now, there are a number of other documents that I would urge you to put on the government website. The British sent us in November 2019 2 documents. They delivered 2 documents to us that the public have never seen. One is their proposals to amend the different fundamental rights sections. They set out in detail each amendment to each section in the fundamental rights with an explanation of why they considered those amendments to be important. That document was handed out to all of the delegates at the 2019 meeting, and it should be on the website. The proposal in it, the proposals in it have been incorporated into the draft constitution. But when you read it, you don't know that it's something new. People might mistakenly believe that what is in Chapter 1 is what the people of Anguilla long ago explained to first the Commission and then the committee, starting in 2005 and then in 2017. But in fact, there are hundreds of new amendments, and the British have underlined them. They have set them out clearly. They have given their rationale. They've given their explanation. And it would be so convenient and so easy to put that document onto the website, British proposals for amending the fundamental rights. Then there was another section that they proposed, which, again, members of the Anguillan public have never seen, and that is their section setting out the powers of the governor. They've incorporated it in the Constitution, but we have had it since November 2019, and the Anguillan public knows nothing about it. I would urge that they be given a copy of it on the website. Now, the Anguillan public, in discussing through the reform period that I was involved in, have always expressed the view that cabinet should be chaired by the premier. The cabinet should be under the control of the premier because we're preparing ourselves for full internal self-government. We're trying to get to a situation where Anguilla will one day become independent. We need to prepare ourselves for future and eventual independence when the premier or prime minister will chair cabinet meetings. We need to give him practice, so to say. I don't mean as an individual. We need our institution of premier to become imbued with a sense of the responsibilities and the burden and the privilege of being the chair of cabinet. But the British have obviously decided that they don't see how that makes sense. Perhaps, for example, they wonder what use the governor would be, because the governor was intended to be in cabinet meetings. In the draft that we prepared, reflecting the views of the people of Anguilla, the governor was going to be invited to cabinet meetings. But he was going to be sitting down there, and the British probably thought, good Lord, what is he supposed to do? Maybe get the coffee for the members of cabinet or something? What role is he playing? So they are proposing that he should be reinstalled as the chair of cabinet. But they make it very clear in their draft that that doesn't give him any power. He chairs it, he calls upon different members to speak, and then he leaves it to the elected members to make the decision. The governor does not make any decision or participate in any of the decision-making in cabinet. He is there to chair the meeting and to guide the discussion and to keep things going. Well, I suppose there's sense in that, but it's not what the Anguillan public wanted. So there you have a dichotomy. You have, these two different scenarios in front of us. So yes, the answer to your question is that the Anguillans wanted the premier to chair cabinet meetings, but the British are proposing in this draft that it be the governor who chairs the meetings. Thank you.
Thank you very much, Mr. Mitchell. I just want to assure you that we will ensure that those documents are put up on the government website. I know WhatsApp now is dominating a lot of our social media platforms, and certainly these documents can also be shared via WhatsApp. So if you send me your WhatsApp number, I can easily send it to you via WhatsApp, and it can be shared around, open on your phone and read, save paper, and protect the environment. And Mr. Mitchell, just one other thing as well. You mentioned the fact that we are, going ahead with these sessions. Again, we want to ensure that we have no agenda with this constitution reform is concerned. We are an open book at this point in time. We want to hear what the people are saying. Some time has passed since the last round of talks. Persons may have forgotten about it. COVID has dominated every sphere of our existence since. And we want to begin to awaken persons' interest in this topic again. And that is why we're having these town halls, one every week, each of the districts, so that people can begin to think about the issues that were dominating back then. And hopefully when we finish these round of talks, then we begin to have more focused discussions on the different aspects of the Constitution. So this is going to be a continued process until we re-engage the British family again. So thank you for those comments. The floor is open. Yes, we want to welcome our Reverend Wilmoth Hodge to the microphone. Thank you, sir.
Good evening. Any attempt at constitutional reform is highly commendable, and so I want to commend the government for this initiative. However, I want to ask you as representatives of government, if you believe that this exercise is meeting its objective at this present time. As you know, you are moving from one constituency to the other, and this evening you are in the West End constituency. And I happened to turn up to this meeting. The meeting had already commenced with no member of the West End public being present, and the meeting has continued. As far as I can see, there are only 3 persons here from the West End community at this meeting, and I know that you are also catering to persons who are viewing online. However, you know, I want to think that this process will be better solved at a time when we can have more involvement from members of the constituencies across Anguilla. Now, one of the reasons why it is important that we have greater representation from the districts is, in fact, to be able to discuss some of the important issues that have been brought up this evening and in the previous meeting as it relates to electoral boundaries. And you would have prefaced your opening remarks about the electoral boundaries on the fact that we are in one of those constituencies that is deemed to be a small constituency on the political landscape in Anguilla, which is West End. And I want to ask us a question this evening as it relates to that point. A constituency may be small in terms of the persons that live in the constituency that are registered to vote in the constituency, but a constituency may also be a high-value constituency in terms of the value of its territorial boundaries. And this is one of those constituencies where the constituency has a high value in terms of its territorial value. You know, it can be said that the West End constituency is the breadbasket of Anguilla. And I want us not to lose the essence of what constituency representation means in a small island like Anguilla. Democracy is a fight to preserve the values of a people in whatever locale they're situated in. And there are times when the people of this constituency, as small as it is, had to fight for their territory. You know, things that were happening in this constituency that persons in other parts of Anguilla may not have been concerned about. A good example of that is what is happening right now, not in the total constituency, in a particular village in Anguilla, let's say Sandy Ground, where there is a hot issue as it relates to the marina. And the people in Sandy Ground are fighting a territorial battle. The rest of Anguilla may never understand the battle that they are fighting, but they are fighting, as small as they are as a community, they are fighting a territorial battle. So when it comes to a small constituency such as this one, I want us to understand that there is value, and the people in the constituency are people who will fight for their territorial boundaries and they will do everything to preserve their territorial boundaries. And whereas, I've heard the discussion about increasing the number of electoral seats in the House of Assembly, and I wonder, if something is not broken, I don't know who considers it to be broken. Why fix it? Why is it that we cannot have that kind of discourse that is being suggested if you have more electoral seats? Why is it that we can't have that kind of discourse now? With the present number of persons in the House of Assembly, 11 persons in the House of Assembly, do you think we are going to have the kind of discourse that we want in the House of Assembly if we have 13 opposed to 11? These are questions that I want us to be able to answer. And the best people to have the discussion with are the people in the heart of the constituencies. And as I said, tonight is not a great reflection of the constituency, of constituency representation. And I will hope that we do not, just think that because we have the wider outreach in terms of the social media, that we are reaching the constituencies when we are in the constituencies such as we are tonight. The other question that I would like to ask is, as it relates to belongership. I don't think I heard much discussion on the question of belongership. Now, one of the things that have been, one of the issues that have been spoken about much during the campaign on some political platforms is the fact that if Anguilla is going to become a sustainable nation, we would need to increase our population. Now, in our Constitution, I don't know if it is a part of the revised Constitution. I'm not certain about that. Is there any attempt to change the present, what is in the present Constitution as it relates to persons who are born in Anguilla of non-belongers, of non-Anguillians? There are many persons who live in Anguilla, who have had children born in Anguilla, and they cannot have birthright citizenship or belongership in Anguilla, even though they have been born in Anguilla. I think that this is something that should be put on the front burner as it relates to belongership in Anguilla. Why do we disenfranchise persons who are born in Anguilla? Almost every country on the earth, citizenship is obtained by birth, where you're born. And today you have persons who have been born in Anguilla, left the island, and they do not have any rights in Anguilla. I think that is something that needs to be changed. I'm going to just rest that for a moment. I'm just going to rest there for a moment, and I would like for you to respond to what I presented so far. Thank you.
Thank you very much. You have raised some thought-provoking questions, and I really want to thank you for sharing with us. I just want to deal with the questions. The first one, you spoke about the timing of the meetings. As you know, the round of constitutional talks were put on hold until after general elections. And since coming to office, we'd have had the challenges with the COVID the various lockdowns that were taking place. We don't know how the COVID pandemic is going to continue to affect us. We know we have a number of cases at this point, but I suspect it's going to be the new normal for us in Anguilla as it is in the other regional islands and the world moving forward. And as such, we felt a need to begin this process. I have no idea what 2 weeks, 3 weeks, 4 weeks down the road will bring. And so we thought it important at least to begin the process. And you identified one of the reasons why we are going to each of the districts. We wanted to give the persons in each of the districts an opportunity to be part of this process. We have the current health restrictions in place that limit the number of persons, and as a matter of fact, someone online just referred to that we currently have the 25-person limit on gatherings. And I think tonight, at midnight, we're going to be making some changes via some new health regulations, which come into effect at midnight tonight. But to answer your question, sir, we can't predict what time will be a good time to have started these round of discussions. The COVID is with us. I suspect it's going to be here for a very long time to come, and the business of the people has to go on. We are happy that we have teamed up with Anguilla and DITES to at least provide a forum by which the public can still engage in this process. The second question about the electoral boundaries. Again, there are some 5 proposals on the table, and I just want to go through them very quickly. One is that we do nothing, we continue with the status quo, so to speak. 2, where we split districts 3 and 4 into 2 separate districts, so we would end up with 13 elected members instead of 11. A third option is to redistribute all of the 7 districts into 9. So one is just to split 3 and 4 to give 9. Another option is to split the entire 7 into 9. That's 3 options. There's a 4th option to redistribute the 7 districts using the road network. And as a matter of fact, we got physical planning to actually do it for us, and it was really fascinating to see how they use technology to redistribute the 7 districts into more equidistant numbers using our road network. So that was a 4th option. And then the 5th option was to turn Anguilla into a giant electoral district, one at-large district. So Reverend, to answer your question directly, those are the options on the table for discussion. I'm very happy that you have shared your views on that, and we would like to hear from many other people as we go through this round of discussions as to what you feel about the boundaries. Should we keep the 7? Should we split them into 9? Should we withdraw them? We want to hear how persons feel about this, because at the end of the day, this constitution will be about the people of Anguilla, their wishes, their aspirations moving forward. And then again, you spoke about belongership and increasing our population. That has been one of my key campaign promises, so to speak, where I campaigned a lot about growing our population. And this has been a discussion that has been going on since I've been a civil servant. So this discussion is 15 to 20 years old. This is not something that I have invented. This is something that has been discussed in many, many various fora over the years. And I think we have come to accept that Anguilla's tax base is very small. And in order for businesses to really do well, we have to broaden the amount of persons that can contribute to the system. And so that is why I have proposed growing the population in a sustainable manner, discriminating in the first instance to our Caribbean brothers and sisters. And we are now engaging in discussions with our labor, immigration, and other officials to see what existing policies we have in place where we can begin to modernize and bring them into the modern age. You'll recall, sir, and for those of you listening as well, that over the years, Anguillans have traveled the length and breadth of the region and the world. They have settled, they have formed families. And I personally have family in pretty much every Caribbean island around here. French and Dutch, St. Martin, St. Kitts, Nevis, and Antigua. So we all have moved around as a people, and we have settled, we have formed families. And so I think when we talk about population growth and to allow persons who have come here, settled here, and made Anguilla their home, if in some way we can enable them to get some level of status at an earlier time rather than having to wait the 10 or the 15 years, then I think we can explore what options are available to us. It's not going to happen overnight, but it's something I feel very passionately about, and that's something that we are advancing. I hope have I answered your question, sir? Yes, thank you very much. Okay, yes. So that is a good point you have brought up, and I would hope that others would weigh in as we go through these round of talks to share your views. So the point is, should a child who is born in Anguilla, should that person automatically get Anguillan rights? So the PS have noted that as an issue that we will continue to put on the table as we go to these round of talks. Yes, any other comments? Anyone else would like to weigh in? Yes, sir, Mr. Mitchell.
Thank you, Mr. Minister. Not to touch on every point, but just because a legal issue arises on rights for children of non-Anguillians born in Anguilla. The proposal is that any, let us say, German couple who happen to be in Anguilla while the wife is pregnant and they happen to drop the baby here in Anguilla, and then they go back to Germany when their vacation and the postpartum process is over, that child growing up German and never coming back to Anguilla should have Anguillan rights. Well, that is a rule that's found in the United States of America. I think there may be one or two other countries, maybe Mongolia, that gives rights to babies born in the country. But it is not normal. It's highly uncommon. You have to have a relationship with the country where you are born for it to have any justification at all that you be given rights there. Not the accident of birth, as is the rule in the United States of America. So the overwhelming majority of Anguillan views expressed during the reform consultation process was that birth should not automatically confer rights on persons born in Anguilla. That's the point, really. So the Anguillan public is generally speaking against it. There is one thing that the Anguillan public is in favor of, and that is a government matter that could be dealt with administratively. And that is the present very burdensome process, very unfair process, where persons who have come to Anguilla, let us say from Jamaica, or St. Kitts, or wherever, they come to Anguilla to work, they establish themselves here, they eventually get jobs, and they work for 20 years. They have babies born in Anguilla. They have to go every year and pay, I don't know, $50, $500. I've heard different stories. I don't know what is true. They have to pay what for poor people is a huge sum of money every year for this child who, well, Mr. Minister, may I say, we all know the definition of a duck. If it looks like a duck, if it walks like a duck, and if it quacks like a duck, then it must be a duck. Here is this little Jamaican baby born in Anguilla, but it don't talk Jamaican. It talks Anguillan, it goes to an Anguillan school, all of its friends are Anguillan. It grows up to all intents and purposes as an Anguillan, but its mother must go to the Immigration Department every year and pay a significant portion of her salary to allow that child to continue to reside in her home and go to school in Anguilla. And I think a majority of Anguillans think that that is highly unfair. That's the comment that I have been getting anyway. So, but that can be dealt with administratively. It's purely a matter for government to decide, would it be the right thing to do? It will mean losing revenue. It will mean giving up revenue, but does the government really want to extract all or a major part of its revenue from poor people? That may not be the right thing to do. So that would be one reform that would be very welcome. Another perhaps legal matter on boundaries. Reverend Hodge asked the question why we really need to change it. And Mr. Minister, you've mentioned that one of the proposals is to simply split districts 3 and 4. The point, however, is this. The present Constitution says that you can't change the boundaries. You can't just change the boundaries of 2 or any other constituencies. It can only be done by a District Boundaries Commission. Why is that? Because as we know, those of us who follow the United States news, there's a process called gerrymandering, where influential politicians get the boundaries of their district changed to favor them. So this village doesn't vote in my favor. I want to cut that village out and put it in another constituency. This village over here, most of my relatives are in that village and they're not in my constituency. I want to change the boundary to get that village brought into my constituency so I will get more votes. That is what gerrymandering is all about. In order to stop that from happening, the rule throughout the Commonwealth, and certainly in the present Anguilla Constitution and in the proposed new one, is that no political input will be made in adjusting the boundaries. It will be done by a District Boundaries Commission. And you have made the point, the function of the District Boundaries Commission is to ensure, as far as practicable, a more or less equal number of voters in each constituency, because that gives fair representation to people. The District of West End has a huge advantage over North Valley or South Valley. The District of West End only has about 300 voters. I don't remember the exact figure, but somewhere in the region of 300 voters, compared to 1,500 voters in one of the Valley districts. That means that the people of West End have 5 to 10 times more power of representation in the Anguilla House of Assembly than a person from the Valley, because their representation is split amongst 1,500 voters, while the people of West End only have to enjoy this 300 person voter. So that by more or less fairly, it's almost impossible to do it exactly. It has to be more or less distributing the voters amongst the 11. Did we say it would be 11? The 11, yes, the 11, 12, 13. No, the. Yes, 7 plus, we want 7 plus 2, we want 9. The proposal which the Constitutional Committee made, reflecting the views of the people of Anguilla, is that the districts should be increased from 7 in number to 11 in November, to 11 in number. If my arithmetic is terrible, I may have gotten it wrong, but we want to have eventually a total of 13 members of the House at a minimum, at a bare minimum, in order to get 6 ministers. At the moment, we have 7 ministers. In effect, we have the constitutional ministers, and then we've given the parliamentary secretary executive power. She has tourism. She's a minister who is not appointed as a minister, but she has the status nearly of a minister. And then there's at least one of the other backbenchers in the Anguilla House of Assembly who has been made in effect a minister. So we have about 7 ministers of government in Anguilla today. Do we really want that? Because that gives the executive, which is the official cabinet or executive council, plus the unofficial ministers, they are a majority of the House of Assembly. When they go into the House of Assembly, they are not supposed to vote against the government, although we have seen that happen recently to our great astonishment. They're supposed to vote with the government, which means that the House of Assembly is a kind of subcommittee of Executive Council, in effect. So there we are. We need to bear in mind that the proposal to divide the two Valley constituencies into two each cannot be done without a Boundaries Commission, because the Constitution says so. And if we're going to have a Boundaries Commission, they might as well look at all the constituencies and do what is fair for all of them. Thank you.
You want me to comment? Yes, Mr. Mitchell, yes, we know that, and that will be done at appropriate time, but I think for now we were just simply throwing out a number of options, because persons need to begin to think about what eventually will be the composition of the House, the composition of the boundaries, whether it is we'll have one single at large. And you know, at a meeting in Island Harbor, it was also thrown out about 21 members in the House. So there have been various thoughts being expressed as to the size of the House and the composition of the House. But like I say, this is all, at this point in time, we are getting feedback from the public. We want to get your comments. And this session tonight, as well as last week, it is on Facebook, so you can go back when you get home, you can go back and view it and see all the comments that were made there. So it's there for posterity, so to speak. Premier, I see you are itching to say a few words, so yes, sir.
Good evening, and I thank you for making these sessions possible. You know, we certainly know the restrictions. It still would be good to see more people come out, and hopefully by the time we get to next week, there'll be more people showing up in whichever district we're in. I just want to comment, a couple of comments. One is that, you know, we do have what we fondly call the Don Mitchell constitutional constitution, which is the one that is the basis where we are right now. It was done, a lot of public consultation, and started in 2015, was the report came out in 2017, and then the negotiations were done in November of 2019, as you mentioned, after the whole committee of the House on the previous administration had come up with whatever revisions they wanted. At that time, it was felt that the whole Constitution should have been negotiated, and you know, conclusions made and the final. However, the previous administration split it up and took out some parts of it, and by order in council that came into effect in May of 2019. So this process that we're doing right now, nothing is set in stone. This is why you're having these consultations, so that persons have comments to make. You'll take them under consideration, and changes can be done if a majority of Anguillians want certain things. That can be taken when the negotiations start again with the UK negotiating team, that these can be presented. I don't know if, you know, the Section 42, which was the UK negotiating team, brought the list of things, the powers of the governor, if that was meant to be publicized. I know there was a joint statement that was put out after those sessions in November of 2019, and then we would continue negotiating so that we could get a document that both sides were comfortable with, although the Constitution should reflect what Anguillians want. And we do know that there is, as the Permanent Secretary mentioned, in 1980 there was the Anguilla Act, which says, you know, if you want to go independent, you have to ask. That's about. But the other thing is the districts. And, you know, during the campaign of 2020, when we met with persons, there was a desire, by I think a majority, that felt whoever was going to be the premier should run island-wide, so that all the people of Anguilla had an opportunity to elect the leader. And I think that, I feel that all the seats that Anguilla should be one constituency. We're small enough, and even though the reverends say each district has its own unique characteristics and identity, and I agree with that, I think that when it comes to politics, that we should be thinking of the whole nation rather than our own little silos or districts. And so that would be my preference, is that we have a single island-wide district, which is the whole of Anguilla, voting for the 11 persons who will make up the House of Assembly. And I think that, as I go around, I hear many people saying that small districts, District 2, District 7, which have about 900 or so voters on the list, can make determinations for the whole country versus bigger districts like District 3 and 4, which have 2,300 plus voters. So those are significant concerns, and I think if you had one district, Anguilla being one district, then those concerns would not be raised. And then there wouldn't be concerns about equity, whether one district had more persons than the other or had more land space than the other, so that you'd have these territorial battles. So that those would be the points I'd like to make. And I want to, again, thank you for spearheading this, and I think it's necessary. And as we move forward, as hopefully more people will turn out so that they can participate or participate online, where you gave your email addresses. They can call in to the different, to your ministry or to any of us. Even retired Justice Mitchell, if you see him, just slip him a sheet of paper, he'll make sure that somebody sees it. Right, Judge? Thank you. Appreciate it.
Thank you very much, Premier. And I have been just corrected that children born in Anguilla no longer pay for time. This was changed since the previous administration, and they receive extensions for 1 year renewables, so they don't pay for time. So and then at age 10, those children can apply for naturalization. Yes, so I was just updated on that. So basically, children born in Anguilla no longer pay for time. They receive extensions, and at age 10, they can apply for naturalization. Yes, so thanks very much to the Immigration Department for updating me on that information there. So we have a few minutes left, about 10 minutes or so. And I don't know if anyone else would like to share any comments in the audience. No members of the audience? Doc, any closing comments you'd like to wrap up in terms of any things you'd like to highlight?
Well, the observation of my schoolmate Wilmot is apt. I think this is one of the challenges in Anguilla for a long time is participation. Give folks the opportunity to participate, but then there's not a lot of face-to-face participation. But if you take my understanding, just on the Anguilla website, right, from the last evening, apparently there were like over 1,000 viewers, and that was just one platform, because I think it's also being put out on YouTube and maybe a couple other platforms. So I don't know if this is a modern reality that you have to. People may not, may not come and be coming out in person, but they're watching through other media, and so I think we have to ensure that we record their observations, things that people are posting in the chats or and so on, and therefore get a sense of what is important to them, because we want it to be meaningful, so that at the end of the day, when something is passed, folks can say that they had the opportunity to participate and contribute, and their contributions have been recorded and taken into account. I think that there is an obligation on all of us, as you mentioned at the beginning with the quotation from Nelson Mandela. That is how you protect democracy and democratic rights. You have to make the effort, put in the time, all of us, to understand what's happening and make our views known. So I would encourage folks through whatever. For us is nice. It would be nice to get a buzz when you see more people. There's more energy reflected. You feel so that would be great to have more people in the hall, subject to the health protocols. But at the same time, we do also have to realize that, as I said, there are other means of people communicating and letting their views be known. So we have to make sure that we capture them. Thanks.
Thank you very much, Dr. Harrigan. I think as we begin to wrap up, I just want to really thank, first and foremost, our technical crew here this evening, Mr. Gilbert Fleming, better known as Gaff, and his assistant, I'm not sure of her name, and a wonderful job as always, setting up all the technical details and being able to not only provide us with the audio, but also the video and the streaming. Thank you again for the extremely efficient work you do. We want to thank our colleagues over at DITES, the Government Information System, again for facilitating the streaming across their network, as well as Lloyd, Radio Anguilla. We want to thank the members of the West End community who came out here this evening. A special thanks as well to Mr. Mitchell. Yes, thank you for coming out, and again, you are a wonderful resource in terms of sharing information with us. Thank our Premier and our Parliamentary Secretary for supporting this event as well. Just to let you know that we are making plans to be in District 2 next week. So as you see, we are kind of going back and forth across the districts. We just didn't want to go 1, 2, 3, 4. We kind of wanted to zigzag a bit. So we're going to be in District 2. We're going to be looking at a suitable venue. So we're going to, by Monday, we should be able to say what the venue will be. And again, like I said, there'll be some changes to the health regulations as of midnight tonight. And that will allow us to have a few more people present at these events. So that will be made public sometime tomorrow. So thanks again for all of you online who have been viewing and watching. And again, our contact information is there on the screen. Kenneth.hodge@gov.ai, Aiden.harrigan@gov.ai, or Clarion.webster@gov.ai. Send us your comments, your questions. If you would like to get a copy of the British Draft Constitution and other documents that were referenced earlier by Mr. Mitchell, send us an email. We will certainly send them to you. Send us a WhatsApp, and we can also forward you the attachments via WhatsApp. So, good evening again, and thanks for joining us this evening. We invite you to join us next Thursday evening at our location in District 2. We'll announce that by Monday. and have yourselves a pleasant evening. Safe drive home for those of you who have to drive. Thank you very much.